the committee that I anticipate we're to take up 3 bills today. We will be meeting tomorrow at our normal time. So the first bill I'm going to call up is Senate Bill 2472, Tax Sales Committee to reconstitute. That is Senator Suber and Senator McConn's bill, and I'm going to turn it over to Senator McConn.
Thank you, Mr. Chairman. This bill is actually, we'll have an amendment here in just a minute, but it just reconstitutes the Tax Sales Study Committee. We made some great progress on that last year. When we were digging in it, we found that we've got way further to go. So we're asking for it to be reconstituted. And at the proper time, my amendment's going to be that we move it to 3 members on the House and the Senate side, Mr. Chairman, whenever we get to that.
Now's the proper time.
So my amendment would be to amend lines 18 and lines 22 to change it from 2 to 3. And that would allow us to have a little more depth on our committee. We've got some very bright attorneys on both sides that are going to work with us on that. Mr. Chairman, that would be my amendment.
Okay, you've heard the amendment. Any questions on the amendment? All in favor of the amendment, say aye.
Aye.
All opposed, the amendment carries. All right, we're on the
title sufficient due pass committee sub.
The motion is title sufficient due pass committee substitute. All in favor, say aye.
Aye.
All opposed? All right, that carries. Thank you, Senator McConn. Okay, now we're going to go to the first one on the docket, the Senate Bill 2728. And I want to, if the committee will indulge me a little bit, I have some things I want to present to the committee, and then explain those, and we'll go into the bill. But what you have before you, you should have a proposed committee substitute. And the proposed committee substitute, I will tell everybody, has a reverse repealer in it, which for those in the audience that aren't familiar with that, that means that should it pass, it repeals the bill before it goes into effect. This is reverse repealer week, it seems like, but that's how we work on the bill. That's where we are in this stage of the game. So, and the committee substitute came about after hearing from a lot of folks, including youth court judges, AOC, CPS, national outside groups that have relevance to what we're doing. And so the committee substitute is what I call a roadmap to getting us a youth court system that is workable. And as we've had hearings, and that leads me to say I wanted to go over briefly kind of how we got here, because I've heard some questions, and it's been communicated to me in certain circles that this is something that we just came up with at the spur of the moment. And I think this committee is aware that we've been looking at this for going on 2 years now. And so what you have is you have a packet that I'm briefly going to highlight for you, and to go over some things. So first of all, you have a summary used by our friends AI of the filed bill. So I would caution you, use it to look at the bill, but it's AI. So there's even one that says it doesn't constitute legal advice. So, but it does not include the committee substitute. We have, if you recall, we had, this really got started with the final recommendations of the Commission of a Uniform Youth Court System, which was done, a lot of work was put in by a lot of folks, judges. Somebody asked me who all was on it. If you look in the report, there's probably 15 to 30 people, probably 20 to 30 people on it. This report came out and presented an analysis of our youth court system, and also presented an analysis of what we know as 3 possible plans for the structure of the youth court system, remaining it in the same, using the governor's plan for chancery courts or a hybrid. The biggest thing, not the biggest thing, in addition to the data that came out, one of the biggest things that came out of this was the conclusion that the referee system under which we operate currently is not in the best interest of our children. And while I say that, since I'm using that term, at the end of the day, this is about what's best for the children of the state of Mississippi, not in one county, not in Jackson County or DeSoto County or Madison County, all of our children. And so that's the context with which this committee is charged with looking at. So this is the recommendations that came out, and I would turn you to that. Then also what you have in your packet is you have letters from national organizations and particularly youth advocate programs who support modernization of our youth court system, supporting both the House and the Senate bills that are trying to accomplish what we're here to accomplish. I'm not going to sit here and read all of these letters. I will leave that to you, but we have those. Then what we also have is from CSG and from the Council of Juvenile Justice Administrators. And I will say that in this bill, which I will go over, and some of the issues that I've heard is about softening the confidentiality provisions. In your packet is a lot of, not a lot, but it's people weighing in on how it benefits the system, parents, children, to remove the blanket confidentiality that we have in our court system. And to that point, on that, if you recall, we had a presentation in Judd A that was presented to us, and it was remarked to us that Georgia had a similar system to ours, and they underwent reforms just like we're looking at. And many of the complaints or the pushback or the concerns that have been raised in Mississippi were raised in Georgia. And in the presentation, we received information and items of how well Georgia's doing. And in your packet that we received, we had, I'll just point out a comment from the court improvement director in Georgia who said, as a parent attorney, open courts allowed my clients to bring family members or friends with them to hearings for support and encouragement. Family members and friends often spoke up about their desire to care for a child while their parents could not, their availability to host or supervise visits, or their willingness to provide transportation. While I am on the confidentiality provision, I actually spoke with Senator Boyd's youth court judge in Lafayette County and Judge Kilpatrick. And if people didn't know, she is actually taking it upon herself to run her court, lifting the confidentiality rules that have governed so many of our courts. What was said here in Georgia is exactly what she told me on the phone, that it has been a blessing to see the people that have come out to support the children, to help and to address items that they need. And also, there is not a flooding of the courtrooms. And also, as it was said, as she told me, every other court in the state of Mississippi is open. Chancery courts, circuit courts, county courts, they're open. And the judges are given the discretion as to whether and how to close their courtrooms. The problem, as you'll see in your materials, is the blanket confidentiality that has led to questions, distrust, I would argue fear and other things. And so what Judge Kilpatrick has done in her courtroom has run essentially a pilot program to show that these things can work. And it tracks with what we've heard from Georgia. Then in your packet, and I want to mention these because I think this is a good summary, is you have in your packet an email. And by the way, I've been given permission by these authors to present this to the committee. You have an email from Mr. Chad King, who I think does a very good job of summing up what I've heard from many across the state. And for those that don't know, there is a court improvement program that has been meeting and to look at youth courts. And I want to say, I think I saw Justice Branding here. She's been in there along with others who there. And Mr. King, in your email, wrote this to me. Senator Wiggins, thank you so much for your work. I'm attaching a draft article that I've been working on. Yesterday at the task force meeting, he said, quote, everyone knows in this room that the current youth court system is failing and it needs to be rebuilt. We just can't seem to agree on where to start rebuilding. And I think that's a summation of what we've been embarking on for 2 years. When this committee report was established, in terms of the structure, what we got were, and that's fine, were 3 options to say, legislature, you decide because we can't all decide. Well, the bill that's been filed, and I'll go into that in a minute, is the governor's plan for a structure, which is the Chancery Court. And as I've said, Governor Reeves put in his EBR money and the Chancery statewide program. If you look at the email from Mr. King, again, he's written an accountability versus confidentiality, but in his email, he says, the biggest challenge has been inconsistencies in 82 kingdoms that exist in youth court. As a practicing attorney, you know that even Chancery courts can be different. The exception in youth court is that we do not have factors like Albright, Armstrong, or Ferguson, which for those that don't know are the case law in Chancery court. This has led to youth courts being less practiced by attorneys and confidentiality, insulating the true problems with the youth court system. He goes on to say the system as it stands today has created an environment on which the agency in Mississippi carries all the liability and none of the authority in litigating these issues. This draft, it's said draft because he sent it to me as a draft, didn't have a chance. He gave me permission to share this. I think it's a very good summation of where we are and the issues that are facing youth court in the state of Mississippi. And I want to reiterate, this is nothing about any individual because every individual in the youth court system is doing it because they want to. The issue is the systemic nature of how we have this. And that is what we're trying to address, is the systemic nature of the issues that you're finding. And then what you have, and I am going to withhold the name, but I have, the committee members have the name in the emails that from parents and people that work there. And I'm just going to quote a couple things. I'm a parent. This person is actually a family defense and works in the system. I'm a parent with lived experience in the youth court system. 5 of my children were removed in 2017, and I was able to regain custody by working diligently. I am writing to you regarding the confidentiality rules within the youth court. This lack of access often leaves parents without a voice, confused and distrustful of the court systems in Mississippi that are meant to serve them and their children. I would like to respectfully request that you look into this matter and advocate for parents to be granted copies of their court orders. If you were in appropriations today, Senator Hill brought up the amendments that were done that she had to fight years ago to get parents to have copies of the cases. And she implored upon us to work for that type of transparency. Another email. let me start off by saying this isn't just policy for me and my clients. This is our everyday life. One of my children was adopted out from under me as a baby. There's no healing journey language that makes that okay. You don't get over that. You wake up every day and learn how to breathe around it. The second time I came in stronger. I had people behind me, real support. And no one talks about what this looks like in a small town. Your caseworker isn't a stranger. They're your neighbor. They sit in your church pews. Their kids go to school with you. Confidentiality is supposed to protect families, but too often it protects the system. It keeps parents quiet. It keeps mistakes hidden. It keeps people afraid to speak up because they know there's no real protection. These are from parents and constituents and citizens who have an experience with the youth court system. And it's something that I personally have taken to heart. I think this committee has done that because we're trying to reach the right result. And this is the start of a roadmap to try to get there. Now, to be fair, also, you have in your packet a letter from the Chancery Court Chancellors Association, and I will paraphrase it. It says they've looked at it, and it is their wish that we do not eliminate referees. However, they go on to mention that if we do that, they provide other alternatives or other suggestions. And I think that is fair, a fair request, but the referee recommendation came out of the original task force. You also have in your packet a summary of the youth court models between statewide, county, and chancery, and the statewide county court districts plan and the cost that they would involve. Let me say this. I have requested a fiscal note for this bill. That fiscal note has not been returned yet. We are waiting. There's a lot of moving parts. I've had conversations with Chairman Hobson. We are working on that. For those that don't know, I know there's some that do, a thing that was presented to us really as the session started was about how what is called the Judicial Operations Fund, which is supposed to fund our court system, doesn't have the money to do that. And what we were also presented with from the LBO, our budget experts, is that despite county courts being the purview of the county and paying for that, the state has been on the hook to the tune of 65% to 70% of the cost of running these salaries and the county courts, and that includes the youth courts that serve as county courts. In the current law, that is not what's supposed to happen, except it's happened. And so, as we will talk about in appropriations, how are we going to fund those? We're making those decisions. Fees, general funds, those are all to be determined. But those are items that are circling around that we have to address. And so when you look at the costs of these, I'm not oblivious to knowing that this doesn't cost things to the state. But the fact of the matter is we can't continue to pay like we have been and think that we're going to get the system that's going to work. So with all of that as my brief presentation, what you have before you is the proposed committee substitute. And I'm going to highlight some of the changes, and then I will rely on esteemed counsel to maybe summarize of what I miss. But first of all, I'll reiterate that there is a reverse repealer in the bill. That's starting at lines, it's at the very end, section 47, line 2938. Then a lot of what we had heard on the bill that was filed, obviously, as tends to be the case, took effect July 1st. What we have done in the committee substitute, you will see throughout in each section, is what we're calling a stair step, meaning any structural changes do not take effect until July 1st, 2028. So what that means is that should this pass, from now until July 2028, January 1st, everything would stay the same while we continue to assess and look at these things and how they would work. It also means that the county courts, youth courts, have been put back into the bill and will remain there, as the bill says, until these change, if this was to be adopted. Now, what the stair steps reflect is the governor's plan to have chancellors serve as the youth court judges. That's because under the Mississippi Constitution, chancellors are constitutionally allowed to handle those. That's the governor's plan. By doing this stair step, we will allow us to look at these things as we go forward, similar to the judicial redistricting. If you remember from last year, judicial redistricting, there were judicial districts that didn't take effect until 4 years from now. That's basically what we're kind of doing here. Also, much of the committee substitute, like the bill, is actually new law. I'm sorry, strike that. It's actually current law. Most of it, 2/3 of the bill that was filed and 2/3 of the committee substitute is current law. The changes are where, obviously, as you know, where you see the underlined areas and that sort. Let's see. People raise questions about the municipal youth courts. Ethan and I had significant discussions about that, and there is no municipal youth court in the state of Mississippi currently. Best I can tell, and best on the research that Ethan did back in 1979, that's when that existed and the language was still in the act. So we have repealed any references to the municipal youth court sections. Is that accurate?
The last one closed in 2018.
Last one closed in 2018. So there are no, so we've repealed that. Speaking of repealing, throughout the committee substitute, we have repealed, just like the original file bill, items that to update the law and bring it current. Part of the changes are referencing the new My Kids change and addressing those. And Ethan, can you kind of give what I missed on the committee substitute?
Sure. Thank you, Mr. Chairman. I'm happy to. Around lines 408 to 409 is the structure that is by far and away the primary change between what was filed in this bill and the committee substitute, and that's the restoration of the county court judges, and then a chancery court judge in every county where there is not a county court. And that's the primary change, and where you'll see some of the tiers. And then the referees and the designees still remain repealed under this version. And if you see any of the tiers, the differences are the deletions or his designee or youth court referee. And as far as the new language, section 5 on line 448 is some new language that provides for some procedure for the transfer of dockets and then the election of chancellors.
While he is looking that up, I will say we keep referring to the structural and then what I call the substantive. When it's not structural, the substantive part of the changes throughout the bill are recommendations that have come to us from youth court judges across the state, recommendations related to the confidentiality, and I will go over that in a minute, and recommendations to dispositional alternatives. One of the biggest changes or things that have been recommended, and while I'm talking about recommendations, if you remember, we heard from experts about what's going on in other places and what we should be looking at. And let me say, every agency, whether it is Department of Health, CPS, DHS, Attorney General's office, whoever, comes to these committees with experts and says, this is how we think things could be run based on what you've requested from us. And that's what this is reflecting. And one of those, or a big part of this, is the diversion programs. And when I've talked to, thank you, Section 29 is the diversion programs. That's one of the big changes, is adding diversion to the disposition alternatives and actually to the process to allow for diversion before they actually get into the system. That's been in your packet of materials, both from CSG and other national groups. They've encouraged us to do that. In my conversations with different youth court judges and officers, people support the diversion programs. And so that's one of the biggest substantive things that we've done on that.
Yeah, and just picking up on that, Section 12 repeals the Mississippi Council of Youth Court Judges, but it replaces, Section 13 replaces that concept with a broader Council of Family Services Forum for Mississippi Children, and that's on line 720. And it has appointments from the judiciary as well in there. And then Section 15, which Chairman Wiggins mentioned he was going to talk about on line 909, is the main opening up of the youth courts and the lifting of that confidentiality barrier. The only other thing I have to add is that there are no additional chancellors in the bill, and that's on line near line 440. And it says there shall be additional chancellors in each chancery court district as needed to be determined under this section. And then the section's blank as to that. So that's just temporary placeholder language for moving down the road.
Thank you. And since you mentioned Section 15, I'll briefly talk about that. So that's the confidentiality. What the committee needs to know is that throughout this bill and throughout the Youth Court Act, there were repealers, meaning the sections actually would repeal before, I mean, y'all know what repealers are. And so we had to address the repealers. And there is the confidentiality of records and there's the confidentiality of the courtrooms. And so Section 15 is in short dealing with the courtroom, and line 913, general public shall be admitted to any hearing in a youth court proceeding, but not limited to any adjudicatory hearing. The court may close a youth court hearing after certain findings and specific allegations. If you're familiar with the operations of Chancery Court that deal with sensitive matters, they can close the courtroom for those matters. And I will turn you back to the youth court judge in Lafayette County who's had a pilot program and said she's opened her courtroom and it's been one of the best things that they've done because it's created trust in the community. It's brought out people who can actually help with kids, and it has led to very good solutions coming about. So Section 15 does that. Where? Thank you. Okay. Section 18, the significant change is on the records, and what Section 18 says that except as otherwise provided in this section, records involving children shall not be disclosed other than to the following persons. And we've updated those. Part of those include the district attorney's office, which if you were in Judiciary B the other day, last week, there was a big discussion about in the Hattiesburg area where the district attorney's office could not get the records, and that while they were investigating I think it was a murder by juveniles, they would not be given the records. The biggest change in that is allowing for the records to be disclosed to certain folks. And so that's in Section 18. And then throughout, there are other dispositional alternatives to allow for whether you're a delinquent child or a neglected child, what can be done And given actually the judges more flexibility and more discretion as to how they resolve a case that comes before them. And so there's a lot. That's my that's my explanation, my brief explanation. There's probably questions, so I wanted to open it up to questions to the committee. Senator Simmons.
Thank you so much, Mr. Chairman, and thank you for all your leadership as it relates to reforming the system. Since we got this report, I think it was September of 2024.
Correct.
Okay. The proposed committee sub, it still repeals the referees.
Yes.
Okay, and what section is it repealing the referee?
Okay. Line 478, section 6, that's 4320, section 4321, 111, that repeals that.
And Mr. Chairman.
And let me say that on that, I've been asked by judges and others, if the Chancery matter is adopted, can you still use referees? My answer to that was chancellors can appoint masters already. And so there's nothing that would prohibit any of that to appointing masters to handle cases as they see fit.
And I was just really asking the question because I know we had a bill in the summary that we have summarized the original bill, but we don't have a bill summary for the proposed committee sub. Is that correct?
That's right, because AI didn't spit it out. It wasn't around in time to spit it out, but.
And more directly.
But we would have one, should this get to the floor, we will have one to present.
And so I guess the question that I had, because we received this letter, and I'm glad you did mention this letter that we got from the Conference of Chancery Court Judges, and it was dated January the 30th. And I'm quite sure a lot of the members on the committee have chancellors in their respective districts. And so, of course, I got a call over the weekend from my chancellors. And so they specifically were concerned about the abolishment of the youth court referees. And so that's basically my question. I know and I appreciate the fact that we have a reverse repealer in the bill, but would it be any consideration in this proposed committee sub as it goes through the process to consider the fact that our conference of chancellors across the state, they really support the referee system and want to keep that intact?
So to answer your question, sure, as far as I'm concerned, I mean, that's why I included the letter to the committee, because they weighed in and it's there. This is the start of a process. And so as far as I'm concerned, no, that's not off the table. However, I think that needs to be really considered when in 24, people from youth court judges to chancery judges to prosecutors to commissioners to attorneys all recommended that the referee system not continue. Also, in the items that you have from the various experts. Oh, and also from there's one in here from somebody at the State Public Defender's Office. They're recommending that too. So I understand that that's where the chancellors are coming from, but that's something to consider.
And I appreciate that. And I look, Mr. Chairman, at the members that served on that commission, and I see that we had 2 youth court referees from 2 counties. I don't have to name the counties, and I see a list of others who served on the committee.
Right.
But of course, when I received a call from my chancellor, which basically gave me a call subsequent to receiving this letter from the Conference of Chancery Judges, they speak to the fact that 2/3 of the current system, roughly about 56 counties, have this youth court system, and they really find it to be really useful. So I just want to make sure that I'm raising the questions for my constituents who are Chancery Court judges in the Delta who really support the current system, and wanted to respond back to them that it will be fully considered, not
Yes.
only the January 30th letter, but the fact that they are fighting for a system that they believe respectfully really, really works and serves our children.
Yeah, yes, I understand that, but also the question is, well, if you don't have referees, what replaces it? And that's why the governor's plan that I heard about is there to place these chancellors in those areas to serve as a full-time youth court judges in those districts that would replace the referees. I'm not sure the stats, but I don't know of any other state that continues to use that type of system. So, and I think Georgia was the closest one, and they did their reforms a few years ago. But yes, it will, duly noted.
Okay, and it's it, I guess in substance, is the proposed committee sub, is it what we expect to see if the bill, I guess, like abstract a better question, would it be a friendly amendment in support of the Conference of Chancery Court Judges to remove Section 6, and Section 6 repeals the referees?
It would be an unfriendly amendment, and that's why we had the reverse repealer in it, because that won't be the only thing. I mean, like I said, these are things, it's a work in progress. I mean, we've done that for the last, certainly all day today. And so I think we could address that as it goes to the House. In the House, I expect to send their bill over here.
And one last question for now, I think. Do we expect, Mr. Chairman, to get that fiscal note before we vote on this on the floor?
It would be I think if this committee substitute passes, oh, and I should, if this committee substitute passes, then that I think will make it easier to get the fiscal note. We'll have better numbers that we can do it, and that would be my goal.
Thank you, Mr. Chairman.
Yes. Senator Boyd.
Mr. Chairman, first of all, thank you for this difficult task, because there is no way you're going to please a large percentage of people, no matter what you do. But what the worst thing that we could do is not to continue forwarding this legislation, because in many parts of our state, and particularly those counties you just mentioned, our youth court system is broken. And so for the chancellors to say that there's 56 of them or whatever, it's still a broken system. And we've got to address this when you have that this affects not only the youth that enter, it affects our CPS system, because we're not just looking at delinquency. We're looking at those other matters as well. So putting this reverse repealer and continuing this process on, and I don't like the chancellor system. I'll be the first to say that, but I would oppose any amendment on this, because we need to have all options on the table as we move forward. This is messy. There's no way it's not going to be. And I see body language back there, some shaking their head yes, and some immediately no to any option. You get to do that. You're living this every day. But this is something we're all going to have to adjust to, and none of us are going to agree on anything. And I don't mean to give platitudes, but right now the enemy is trying to get a perfect system, because I can tell you probably with every one of those out there, their perfect system is different than the person sitting next to them. So let's please forward that he's put a reverse repealer in here. Let's please forward this legislation. And as one called me today, as I was driving up the road, I said, put it in writing and send it to us. Whatever you don't like, put it in writing and send it to us, and send it to the chairman. So that would be my plea for today, is that I'm going to make a motion that we title sufficient do pass this and keep working on this.
Okay, the motion is, okay, the motion is on the table. I'll take the questions I see, I'll take now. So Senator Hobson.
Thank you, Mr. Chair. as it relates to what Senator Simmons was asking at the end about the referees or special masters, is there anything that prohibits the chancellor or the judge that's in charge of the youth court matter, if they can't get to a county, especially some of our larger districts, anything that would prohibit them for expedience sake to have a hearing appointing someone to take care of that hearing in another county?
No.
Okay.
N-
That would be,
No.
that would be allowed if it's
Yes.
needed by that chancellor?
Yes.
Okay. As it relates to the changing to the chancellor system, this is a concern that I have, and I just want you to address this, where it's working, and I do think it's working in my home county, where we have a county court, youth court system. I understand. I also have, as part of my judicial district, 2 counties that don't have, they're small counties that don't have a county court judge. So they're not getting the same. They're having to deal with a referee, I presume. And I don't do a lot of work in county court, but my experience in the county court in my home county it's been that it's run well, things are done right. If we switch to a chancellor system, is there any assurance that our current or any county court judge or judge that has good experience in this would be eligible? How would they get to continue doing the job that they do?
So, good question. So the bill is filed, not only allowed, it had them being able to automatically qualify in the chancellor position. With the committee substitute, that's been put back, and the language is said to be determined, right? Yeah. Okay, so line 470, to the extent permitted by the Mississippi Constitution and notwithstanding any provision of general law, a person who is a judge within the youth court division of a county court as of December 31st, 2027, may qualify as a candidate to run for the office of chancellor created through the sections in the November 27 general election. So
the person that's running as a county court judge now would be could run for this chancery position, which would include the entire district.
yes.
All right. And do you think, especially for some of our smaller counties, do you think we're going to need county courts in all of those places? Because if you're essentially splitting time, half your time doing county court work and half your time doing youth court work, are we going to have county court judges that aren't needed anymore?
I don't think I understand your question.
Well, I'm just thinking from a judicial efficiency standpoint, and just look, in dollars too. We've talked about that a lot today, and you've mentioned it a few times. If we're paying for a new group of chancellors that are going to essentially be our youth court judges for the entire district, that means that you're going to have county court judges that are doing it now, that about half their workload is gone, right? Am I correct?
Oh, I see what you're saying, that the county court judges would remain that position.
I guess it would be up to the,
Yeah.
I'm asking, would it be
Yeah.
up to the counties then, and maybe the state's not going to fund that anymore?
Right. Well, okay. So 2 things. One, by statute, the county courts exist because a county is over a certain amount, and they said, you know what, we got a lot of people, so we're going to create a county court. But under statute, that is to be paid by the county. That's unfortunate. And so, unfortunately, for various reasons that we've talked about in appropriations, that has not been the case for probably the last decade. The state has been supporting counties to the tune of 65% of the costs. So I think it is certain, and I've had brief discussions with the governor's office. If there's counties that want to have a county court, then they can pay for it. Nobody's going to stop them, and that's an option. But at a certain point, the state can't continue doing what we've been doing. Now, we can get into the reasons why we're in that position. I think we're exploring that in appropriations. But to answer your question, yes, you can have the county court, just like the law says, if you're big enough, which tends to be the big counties, then you can pay for it. And that there's actually in the youth court law, or in the bill, it states that section that if you're a county and you choose to do it, then you're responsible for that cost.
Yeah. And so maybe that'll free up a little bit on the fiscal
Correct.
note, because the state won't be bearing the burden of
Correct.
that county court I'm assuming under this scenario, and the counties, if they want to keep a county court judge, would pay for the county court judge,
Correct.
right?
That's right.
By the way, one little technical thing on our summary, it showed section 30, which I think would have been section 29 for the youth diversion programs. Just something to look at.
Okay.
Look, one final question is related to the confidentiality issue and the privacy in the courts. And again, I've got limited experience in youth courts. I have been in the youth court several times, but not enough to be a pro by any stretch. But there have been a few things that have been brought up in those cases that I personally don't think the general public needs to hear, especially when you're dealing with a child that may have been improperly touched by a sibling. If you're talking about a child that's had some event that may lead, once it's out in the public, may lead to further ostracization, if that's the right word, of that child, further embarrassment when they go back to school. I am concerned about that confidentiality issue. Maybe, and I think you said, and that's a good thing, that the courts can
That's a
make the
specific-
choice. They can opt out and say, or they can decide that they don't want it to be open to the public.
And specifically in a situation like that, that's in the committee substitute on a situation like that, why it can be closed.
How would the court, if you get into a situation and somebody blurts something out in open court and then the child's embarrassed? I don't want to lead to mental issues with children that something's exposed openly. Is there a way for us to know in that system up front whether there are going to be things in there that embarrasses the child unnecessarily or puts them in a really bad spot that causes other issues?
Senator Hobson, logistically, you know what, I would defer to Judge Kilpatrick because she's done that. And to her, it's not been an issue. And it gives the judges the control, just like a chancellor. And so I'm happy to speak to her about that. Also, those changes were made in Georgia and it's been good. So,
Yeah, I hear you. It's going to
But
have,
you're
they're going to have
concerned-
to, they're going to have to be quick, because I know in one experience not too long ago where something came up shockingly to us, and it was talking about the improper touching by a sibling. Again, younger kids, but that's something that if it comes out could be devastating to a
I'm
child.
not saying that's the case, but I'm saying in Chancery Court, those comments get done at times. But that's the judge's discretion they get to control their courtroom. Just like a circuit judge does, a chancellor judge, a county court judge. But yes, it's well noted.
Well, look, finally, I'm just a comment. I know you've worked here very, very hard to get this over a course of a couple of years. I know this is difficult. This is not easy. And there are parts of this that are maybe just really hard to deal with, but I thank you for your hard work
No, thank
on
you.
bringing this forward on an issue that I agree that there are great examples here in the state of how youth courts are run, and there are some areas where I think things are not as good as they can be, for sure. So thank you for your hard work.
Thank you. Senator Turner Ford.
Thank you, Mr. Chairman. And Senator Hobson basically touched on the issue, the concerns that I have regarding children. These are very sensitive cases, and teenagers, children are impressionable. And just in one of my counties, we're having to expend funds to encrypt the channels that law enforcement officers are using because people are gaining access and posting what they perceive to be as news. And if this is an open forum where any and everyone can come and sit, my question would be, what is to protect those most vulnerable members of our community? So what I would prefer to see, and I'm not offering an amendment because I understand there's a reverse repealer, but perhaps if the court is closed first, and then if the youth court judge perceives that it can be open for these individuals who want to come in and help support the family, that would be considered. I just think I have grave concerns about some of the issues that I've seen in youth court. And if they are openly disclosed for any and everyone to reproduce, discuss, however they want, I just think it can be damaging to the
Senator
lives
Turner.
of the children.
Yes, again, well noted. I would say I am happy to get Judge Kilpatrick, talk to her. She's even offered, should we go down that road, a pilot program and offer that. I mean, it's working there. It's working in other places. And, you know, just like we've been told, listening to the ones who are actually doing it. So I think and that's in Lafayette County. If it works in Lafayette County, it can probably work anywhere. Okay, I'm hearing a no. I'm hearing a no. But to your point about I guess you'd call that an opt-out.
I would just like to, I would prefer that it be an opt-in.
Okay.
And it's just, you just never know. And, you know, some adults can't handle these types of reports in the media or in the press regarding them. And I just cannot imagine, you know, children, we hear of teens and young ladies and boys who are committing suicide based on things that are not even public or through their little Snapchat platforms or whatever they have. And I just have serious concerns about it. And if it stays in the bill, I cannot support it.
I certainly think what you're offering is fair, and that's what I'm saying. I'm willing, as chairman and working on this, to sit down with anybody from this point forward, which I have been. I think we've been very transparent on this, to try to get items like that into the legislation that works to do that. And I'm committing to you, and I think that's worth discussing, because I think the concerns are valid that you're mentioning. But the fact of the matter is, there are, as has been said in these things that I've presented, 82 different systems of justice going on, and we're trying to at least get somewhat of consistency. And while I'm saying that, before I ever sat in this chair, before Senator Hobson ever sat over here, there was recommendations from the Supreme Court to do a uniform chancery court system. So this has been going on for decades. And as was said in the email, everybody agrees something needs to be done. We just can't agree on on how to do it. And we're trying to present a roadmap that we can get there and do it. But these are all valid issues. That's also why the stair stepping that we put in the committee substitute, that gives us some time to address these things and figure these things out, or at least conceptually. Senator Barnett, and then we'll go to the motion.
Thank you, Mr. Chairman. Bryce, Mr. Chairman, I think you and I have probably went around this Capitol many, many times on legislation dealing with criminal justice reform. And as the Chair of Corrections, you know, one thing that's always mentioned when we talk about reform is to make sure that we keep intact the violent crimes. And that's always referenced in code section is 97-3-2. Make sure that that's enforced, that we don't let our violent people out into society to cause any more harm, because we want to keep society safe. But in looking at this bill, I think that we should take the same necessary steps to keep our children safe in the court of law. And as Senator Hobson, Senator Simmons, and Senator Turner Ford has already expressed, is that we don't know what could potentially be said or done in these youth courts. And I think that we need to make sure that our children who are most vulnerable should be protected. And you just made a statement that said that it was a recommendation by the Supreme Court.
The Children's Justice Commission back.
Yes. But I think there should be a recommendation also by this body to keep our children safe, especially in the courts where there is a path for them to have some type of safety. And I don't think that should be overlooked. And I think that's a concern of most of us here in this room, is that what happens to them in a court of law if the general public and everyone else is there to see them or to hear what's being said. And I think Senator Hobson said it best, is the embarrassment to face their classmates, their peers, after something is openly said, whether it be true or false in a courtroom. So I'm just asking this body to consider our children, just like this body has asked me as the correction chair to keep our general public safe. Thank you.
Thank you. And to that point, I will add that I think you were in Judiciary B when we heard from the Attorney General's office and others how concerned they are about youth that are possessing guns and that kind of crime. So we need to, there's a lot of concerns, but what you're saying is the whole point of the youth court system, to give the children a fresh start when they get the use a fresh start when they get to 18. So, all right, we have a motion on the table. Senator Boyd, you want to restate your motion and close on that?
My motion is title sufficient, do pass committee sub.
Motion is title sufficient, do pass committee sub with the reverse repealer. All in favor, say aye. Aye. All opposed? The ayes have it. On the motion. Okay, that's the, is that the? Okay. All right, next one, we will go to Senate Bill number 2026, Asbestos Action Over Naming Reform Act. Oh. Where do we add the committee sub? Right after the vote. Okay, Senate Bill 2026. You have a committee sub. What I'm going to give a brief explanation of this. And what that is in short, many of you are familiar with the asbestos litigation that has gone on in the state. This is effectively initial disclosures that are to be required upon filing of an asbestos action. And if you will look in the committee substitute, you will see in section 1, actually section 3, the required disclosures. The point of this is really twofold: to get the ones who really need actions of the courts who have been harmed by the products. And in asbestos litigation, there has unfortunately been a too much, I guess, too many joining of parties, and it doesn't get to the real root of the cause, which is what I call the nexus of the exposure to asbestos. And if you look at in section 3, starting at line 31, that's what I call the initial disclosures. And stating the manufacturer, the brand name, trade name, location of the exposure, beginning and ending dates of each exposure, and providing that will allow efficiency to dictate. It will allow a streamlining of the process, and it allows that discovery is still available to all the parties. And it is to the benefit of the litigants that this occurs, because the parties and the attorneys can focus on what needs to be done. So with that, that's the explanation of the bill, and I'll take any questions. Senator Simmons.
Thank you, Mr. Chairman. I guess as a general question, do we have this level of or requirement before plaintiffs file any other cause of action in the state of Mississippi?
I'm sure in medical malpractice cases, I think there's that. I think in certain other cases, but that's the ones I can think of.
My concern is, and I know you referenced in your presentation, section 4, that if the plaintiffs do not make the necessary disclosures as outlined in section 3, like the manufacturer or seller and brand and trade name of the asbestos containing product, subsection B, the location of the exposure, including for any person through whom the plaintiff alleges exposure, the beginning and ending dates of the exposure. Like it's almost like a lot of this information is usually, contained in the discovery process, or the availability of getting this information is in the discovery process. And I guess my general concern is access to the courts, and to require a plaintiff to know all of this information before filing suit. And if the plaintiff does not know this information, then of course, section 4 applies, where the cause of action will be dismissed. That's my general concern.
Well, I think, so my response to that is, I've heard that, I guess, issue raised. And what the bottom line is, if you're filing a lawsuit, you need to have a general basis of why you're filing it. And generally that's, if you're in asbestos, it's my client or the plaintiff had an exposure to some kind of product. I mean, that's the basis of it. And, not to get into technicalities, but Rule 11 and all those things. I mean, to me, that's the basis that you could actually ask for. And so, but you can develop the rest of it through discovery. And so, also, as you know, you can amend complaints as you find out more. The problem is in the state and other states is that people are being joined that have no connection whatsoever, or being sued that have no connection whatsoever to the product. And so then they're undergoing costs, they're undergoing fees and all that goes along with that. This is simply asking that the nexus be produced upfront, similar to a medical malpractice case, before you cost to both the plaintiff and the defense gets too high.
And I know our rules under Mississippi Civil Procedure 15A allows an amendment to the actual complaint, and so, and based upon your response to my general concern, would it be a friendly amendment to allow, before dismissal, the plaintiff an opportunity to amend before we just outright dismiss it?
I'm not in a real friendly mood right now, so
Okay.
no, it wouldn't be.
All right, so last question.
If you're asking of the chair, you can make whatever amendment you want.
Okay, well, let me ask you this. You mentioned earlier we at the last 2 days of, I guess, deadline, and so this is the reverse repealer part of this of the legislative session. Would it be a friendly amendment to add a reverse repealer so we can continue to look at this? I certainly see both sides, the plaintiff side as well as the defendant side, but would it be a friendly amendment to keep the bill moving and just to add a reverse repealer?
Same response.
All right. Thank you, Mr. Chairman. But I do have that motion at the appropriate time.
Okay. Senator England.
Thank you, Mr. Chairman. Just a question or two here, and I think this is a very good bill that addresses a big problem, which is why I agreed to co-sponsor the bill with you after discussing.
You're my friend.
That's right. We'll see, you are friendly now. I just wanted to ask a few questions to make sure that I understand the problem correctly. Do we have a situation now where, let's say someone there's a brake pad at an automobile, auto parts store that may be known to have asbestos, and they go see an attorney about it, and they can't remember where they purchased it or what they did with it. So that attorney will then just cast a very broad net and maybe sue anyone or make anyone a defendant in that lawsuit that may have that brake pad or whatever product it may be, and require that entity that may have never even been involved with the plaintiff or may never even have seen the plaintiff, then have to answer discovery, attend depositions, or even offer a settlement to try to get out of litigation at that point in the litigation, which thereby increases insurance costs on pretty much everybody across the board for something they weren't even involved in because a plaintiff's attorney didn't, narrow down the defendants that actually needed to be involved in the lawsuit. Is that what we're trying to do here?
That is, and to just kind of expand on that, if to your point about it unnecessarily raises costs, it unnecessarily, chills business in the state. If we're business friendly, then this is a bill that you want to vote for. Last time I checked, Republicans are business friendly, so I would think that we would want to vote for this bill. And so, yes, that's what we're trying to address.
Thank you, Mr. Chairman. And just one final question, just knowing the process. If during discovery, a plaintiff's memory catches up with another plaintiff or another defendant that needs to be named, they can always add that defendant later on through that discovery rather than just naming everybody up front in one big broad lawsuit that brings a lot of attorneys to the table and potentially a lot of settlement money just to get out of a claim. Is that correct?
That's correct.
Okay. No, I think this accomplishes that well. So
Thank you. Any other questions? All right, do I have a motion? Oh, amendment. Oh, Senator Simmons, you have an amendment. You withdrawing your amendment?
I'm business friendly, Mr. Chairman, and I am a Democrat. I will withdraw my motion because I know the fate of my motion, and I've expressed my concern with the
It
bill.
hadn't been voted on yet.
Thank you, Mr. Chairman.
Okay, it's withdrawn. Do we have a motion is title sufficient, do pass? Committee sub. All in favor, say aye. All opposed? The ayes have it. Okay, that concludes for today. I'll entertain rise and report. We will see you tomorrow.
That's here.
I think this one's yours. All right.